Thanks everybody for being here. So as Brittany indicated, today's webinar is on one of the adjudicative guidelines for national security clearances, Guideline M, use of information technology. This is actually the last of the 13 adjudicative guidelines for people who are trying to get clearances. As Brittany indicated, my name is Ryan Nerney. I'm the managing partner of the Tully Rinckey California office, and I'm also an executive board member of the National Security Lawyers Association. So on today's webinar, we are going to go over the disqualifying conditions, the mitigating conditions, some types of, I guess, common issues that we see for Guideline M, and what some guidelines that could potentially be combined with Guideline M that we typically see. And as far as, self-reporting is kind of a general overview of, what you should do to self-report some potential security violations. So as a disclaimer, this is not intended to be any legal advice. The views expressed in this publication are mine and do not imply any endorsement by the Office of Director of National Intelligence, Intelligence Community, DOD, or any other U.S. government agency. So the topics of discussion, as I said, are going to be Guideline M, disqualifying mitigating conditions. Now, what Guideline M is, it's the use of information technology guideline. A lot of people get this confused with Guideline K, which is handling protected information. Sometimes those go hand in hand, but ultimately they don't necessarily need to. Guideline M is primarily just for information technology, the use of information technology, and really it should say the misuse of information technology, because that's really what this is. The majority of what we see is a misuse of some sort of IT system. So essentially, the SEAD 4, the Security Executive Agent Directive 4, which houses the adjudicative guidelines for security clearances, under this guideline, that particular regulation indicates that Guideline M concern is a failure to comply with rules, procedures, guidelines, or regulations pertaining to information technology systems that may raise security concerns about an individual's reliability and trustworthiness, and also calls into question the willingness or ability to properly protect sensitive systems, networks, and information. Now, the language there is important because it says protect sensitive systems, network, or information. It does not specifically say classified, although there are some aspects of the disqualifying conditions where misuse of classified information can elicit a Guideline M allegation. But as far as IT systems go, according to this specific guideline, that includes any computer-based, mobile, or wireless device used to create, store, access, process, manipulate, protect, or move information. Can include any component, whether integrated into a larger system or not, such as hardware, software, firmware, that are used to enable or facilitate these particular operations. The majority of what we see are obviously computers, any type of media like thumb drives, CDs that I'll talk about in a second, things like that really kind of elicit this guideline or misuse of those particular things. So the disqualifying conditions, I don't know why this says Guideline G, but Guideline M has 8 disqualifying conditions. They're pretty general. Sometimes, in a lot of these guidelines, they typically try to be general as well, so they can fit a lot more potential security concerns within those guidelines. But essentially, these 8 disqualifying conditions are unauthorized entry into an IT system, unauthorized modification, destruction, or manipulation of any type of IT system or data in such a system, use of any IT system to gain unauthorized access to a system or a compartmented area, secured area within that system, downloading, storing, or transmitting classified, sensitive, proprietary, or other protected information. This one's important because this is a disqualifying condition that can also elicit a Guideline K allegation if there's any type of transmitting or downloading or storing classified information that was not authorized. And then the general catch-all disqualifying condition is the unauthorized use of IT systems. So essentially, if you're using an IT system where you're not supposed to, or in a way that you're not supposed to, accessing various different websites that you're not supposed to, anything like that can elicit this and trigger that particular disqualifying condition. Also, the introduction, removal, or duplication of hardware, firmware, software, or media to or from any information technology system. Sometimes people get in trouble if they introduce like a thumb drive or something like that into their work computer. That potentially could elicit one of that particular disqualifying condition. Negligence or lax security practices and handling information technology despite being counseled about that. So a lot of times, if it's just a simple mistake or something along those lines, that's not overly serious. A lot of times you'll be counseled by, your manager or somebody in security or the security office. But that doesn't necessarily always elicit a security concern unless there's some sort of, major issue, a leak of classified information, a potential compromise for classified information, something like that. And then any misuse of information technology, whether it's deliberate or negligent, that results in damage to national security. So I have here obviously misuse, intentional versus negligence. It says whether it's deliberate or negligent. Negligent, it would have to be, again, it have to be something more of like, just a minor mistake. A minor mistake doesn't usually rise to the level of negligence. Obviously, if it's a misuse and it's intentional or deliberate, then obviously, that kind of triggers this potential guideline. So those are the typical things we see for the disqualifying conditions. A lot of things that trigger this guideline are, like I said before, introducing, some sort of media into your work computer, using a work computer to access any inappropriate websites, which I've seen on a number of occasions. Doesn't necessarily have to be inappropriate. It just could be something that is against your company or the agency policy as well. Particularly if there is a potential for classified information being leaked or compromised, that could cause a major issue with the use of IT systems. But typically what I see is introducing or downloading something or just not using the IT system in accordance of what you should. That could even be as simple as checking your personal email if that's against your company or agency policy, especially if you're trying to access those particular programs inside a SCIF or something like that, or a protected area or sensitive area. That could definitely elicit the Guideline M allegations. Now, the good news is that even if there are some disqualifying conditions that are triggered, there's also mitigating conditions like with any other guideline to try and alleviate those concerns. For Guideline M, there are 4 mitigating conditions. These include, so much time has elapsed since the behavior occurred. It happened under unusual circumstances. It's unlikely to recur. Does not cast doubt on individual's reliability, trustworthiness, or good judgment. This is pretty much if it's like a simple mistake, it's not a pattern of behavior. There's no spill of classified information, and maybe there's some unique circumstances that are going on at the time. Maybe, you're going through personal issues and you just weren't thinking correctly when you, put your thumb drive in. Maybe you're going through a divorce and you're trying to get your financial records or something like that, where you're using, work computer to obtain that information. It's not necessarily allowed. If that does elicit a Guideline M allegation, this mitigating condition could potentially provide some relief there. Another mitigating condition is the misuse was minor, done solely in the interest of organizational efficiency or effectiveness. A lot of times I've had circumstances where individuals have used other employees' passwords to access a particular system, which is a big no-no, but I've had circumstances where that was, this mitigating condition was actually used because it was used in the interest of organizational efficiency. So for instance, in a circumstance I had, if somebody was using another password because theirs wasn't working and they really needed to, get something that was time sensitive, whether it's classified or not, to utilize that. They went through the proper steps, asked the appropriate people if that's something that they could do in order to meet this deadline. We were able to utilize this mitigating condition in order to mitigate those concerns. Another mitigating condition you can use is the conduct was unintentional or inadvertent and was followed by a prompt good faith effort to correct the situation and by notification to appropriate personnel. So again, this comes into play if there is not really a major issue, there's not a pattern of behavior, but again, it was unintentional. It was a simple mistake, and you took the necessary steps to remedy that. And this is kind of where a self-report kind of comes into play as well. So for instance, if you do know that there was some sort of unintentional misuse of information technology systems, or if there was, I don't know, something popped up and you accidentally left a website open that you're checking your email or something, and you did it in a skiff or something like that. If it was a simple mistake, it was unintentional, it was inadvertent, and you reported that. So again, you self-report whatever a potential security concern is, that would elicit this mitigating condition. It is important to self-report these types of things because if somebody else finds out about it and it is reported and it determines that it's something that you should have reported, that could also elicit a guideline E allegation, which is personal conduct. And personal conduct is typically more difficult to mitigate than something that could have been resolved at the time of the incident. So, and the last one is the misuse was due to improper or inadequate training or unclear instructions. For this one, it's basically if you were not trained properly in how to use the IT systems, or if I've had circumstances where somebody wasn't sure about how to handle a certain situation, like can I bring this in? Can I not bring this in? Can I go to this website? Can I not go to this website? And they asked the supervisor and they asked the security office and they received in writing that they were able to do that. That would elicit something like this, where you received inadequate training, you were improperly advised, by somebody in those circumstances, or they didn't provide clear instructions. I've used this mitigating condition on a number of occasions in order to mitigate some concerns under this guideline. So there are ways to mitigate these circumstances. Sometimes if it's a minor mistake, you could undergo some additional training on how to use IT systems. There's various different ways and websites that you can use to get that training, to kind of make that argument that this was a mistake, you've learned from it and you've grown from it, and you've even done additional steps in order to try and mitigate those concerns to prevent this type of incident from happening again in the future. So there are other ways that you can mitigate these concerns, but generally speaking, when you have a guideline M allegation, these 4 mitigating conditions are important to argue, and they do give you some ways to alleviate any potential issues. All right, other guidelines in conjunction with Guideline M. So I kind of mentioned a few of these before. I mentioned Guideline E and Guideline K. The most common, those are the 2 most common I see that are combined with Guideline M. Typically, Guideline M is combined with Guideline E because Guideline E is just a catch-all guideline. So if there's not one, perfect fit for an allegation to fit on one of the 13 adjudicative guidelines, they'll usually throw Guideline E in there as well, because that basically is just generally, there's actually a disqualifying condition that indicates if this doesn't fit in any other guideline that you use Guideline E. So, but a lot of times you see people not self-reporting these issues, trying to hide it, not reporting a misuse of information technology system, issue, things like that. Sometimes I've even seen individuals who, in their youth, they used, I don't know, like LimeWire or Napster or whatever those things are to download movies, or some sort of, like Pirate Bay or something like that to illegally download movies. And they failed to report that on their SF-86. or they find out about it later and it wasn't reported. That could also elicit both a guideline M and a guideline E allegation. So things like that could elicit those two together. And then, like I said before, for guideline K, that's the handling of protected information. So that's essentially if you misuse any sensitive or classified material that potentially could cause a compromise of classified information. A lot of times these are combined with each other because they kind of go hand in hand a little bit. If you're, accessing a website, let's say you're using, your computer outside of a SCIF to access classified information, and within that use of the computer, you're also, going to pornographic websites or something like that. That could elicit both of those guidelines because you're misusing the information technology system, not using it in the way that it was intended or you were instructed, but also handling protected information because you're not doing that appropriately within the guidelines or the way that, it should be used. That potentially could cause a compromise of classified information. So that's where those kind of guidelines come in. But again, I mean, most of the time, I see those two guidelines, guideline K and guideline E, in conjunction with guideline M, or guideline M by itself. Now, some of the cases that I've seen, I've actually had a very interesting case a few years ago where an individual was working for a government contractor and they utilized a CD, so a compact disc, on their work computer in order to obtain just their personal files, not any government information, not any proprietary information, not any classified information. They had some personal files saved on their government issued computer, and that ultimately elicited both a guideline M and a guideline K case for proprietary information. It wasn't classified. Essentially, we were able to win that case, and that individual was able to get their clearance because there were no regulations that prevented him from doing that, both with the agency that he was working with at the time and also his government contractor. So we were able to use that mitigating condition. The misuse was improper and was due to improper and inadequate training or unclear instructions. We were able to use that mitigating condition in order to get a favorable determination for that. So that's just one example, but there are obviously other cases. Again, if one example I gave previously is if you're using somebody else's password, but it was essentially an emergency, something along those lines could potentially elicit one of those mitigating conditions. But again, those are the most common things that I see, and the most common, if you're able to mitigate the concerns, if it's not a pattern of behavior, if you do this multiple times and misuse, information technology systems multiple times, that's going to show the adjudicators that there's a pattern of behavior, and that's going to be a little bit more difficult to win. And the best thing to do in those circumstances, if something like that happens, is to report it and self-report it, because it's better to report, to try and nip it in the bud at that point, as opposed to hoping that it just kind of goes away. So that's pretty much the gist of guideline M. As I said, there's 13 adjudicative guidelines under the SEED 4 that the adjudicators look at in order to determine if somebody should obtain or maintain a security clearance. So those are the general things that we see for this. Let me see if we have any questions based upon what we were discussing here. And again, while we wait, I just want to reiterate the fact that there are 13 adjudicative guidelines. There were some other webinars. That we did on the other 12 adjudicative guidelines. So if you haven't seen any of those, I know I did a few. Dan Meyer did a few. Brittany Forrester did a few as well. If you haven't checked those out, those are good ones to review as well. One of the questions is, what would investigators consider a pattern of behavior? So a pattern of behavior essentially is engaging in the same type of conduct on multiple occasions. So it really kind of depends on how egregious it is. But for instance, if let's say that you make a mistake and you put a thumb drive into a work computer that you're not supposed to. You report it, you tell your manager about it, and your manager counsels you, says, hey, this is against policy, this is a policy that's applicable to it, that's not something you should do. And then 2 weeks later, you do it again. You counseled one more time, and the same thing, maybe this time you get a written counseling, right? 2 weeks later, you do it again. Now, while all three of those situations could potentially be mistakes, if you're consistently doing the same thing, especially after you've been counseled about something, that would typically show that there's a pattern of behavior. And it doesn't necessarily even have to be a situation where you're counseled on it. If you're consistently doing these things, and you've done it multiple times, a lot of times they will assume that you are familiar with the agency or government contract or policy to not do that. So if you're consistently engaging in that type of behavior, that could potentially elicit a pattern or show a pattern of behavior in that regard. But it is a little based upon whoever's reviewing your case. Some adjudicators are 100% by the book, others aren't. But most of the time that would be considered a pattern of behavior. Another question we have is, could you explain more about pirating? What if the individual pays a certain amount of fees to download movies, software to a site that is legitimate is in question? So that's kind of a gray area, but the general rule is, even if you pay, to access a site, if that website, and this, is getting that content illegally, and you are obtaining that information, through that website that is obtaining it illegally, that typically would be something that, you're not supposed to do. So they would, and I mean, pirating by itself is there's a very, very gray area regarding, legal aspects to that. But when it comes to security clearances, most of the time that's viewed in a negative light. So for instance, like there's some, in the past, there's things where individuals have, reported to downloading music via like LimeWire or something, right? Seems legitimate or whatever, but ultimately, they were essentially not paying for the music or the content that they were getting. And a lot of times the adjudicators look at that, not necessarily if you pay a fee to access these things, but if it's obtained illegally, then that's something that they look at and they frown upon. And that could potentially elicit a Guideline M allegation. I've seen it both ways. I've seen individuals who have reported that and it hasn't really been an issue. And I've seen where, they have reported it and it was an issue. Sometimes it's, downloading, I don't know, like the Microsoft Office, which is a fairly expensive thing. Other times it's downloading maybe one or two music videos or something like that. But it really comes down to the investigator, and if the investigator kind of determines that that's something that is an issue, but either way, as long as you maintain a sponsor for your clearance, if there are any issues, you should get an opportunity at least at some point to at least address that, whether it's during the investigation or the adjudication process. So it looks like that's probably all the questions that we have. I just want to thank everybody for attending. And once again, there's other webinars out there for these, adjudicative guidelines. So I encourage you to check those out if you haven't done so already. Thank you so much.